A former Winthrop University police officer facing more than 50 sex crimes charges was set to go to trial today. That was until his defense attorney accused the York County Solicitor of a discovery violation.
And the accusations against this man are just troubling, to say the least. Let's give you some more context on this. Charles Eugene Price is accused of sexual misconduct against multiple minors between 2007 and 2019. Now, one of those victims' cases was scheduled for trial, but instead, it was continued after the judge heard arguments from the lawyers on some serious evidence issues. Our chief legal correspondent, Tim Iyer, was the only reporter in the courtroom today and joins us live now from the Moss Justice Center.
So, Seema, give us some background here and what exactly caused this delay.
Okay, so Price was arrested in October 2020, even though those charges all stem from incidents prior to that. Now, after he was arrested, more evidence unfolded and more evidence was turned over to the prosecution. So throughout this case, from 2020 till now, evidence has been turned over. But it was Friday that the defense said they got a document dump, an evidence dump. And discovery also means evidence. So that's what I'm talking about here. Now, let me get specific with you. We are talking about 17 hours of interviews from both witnesses and victims, over 200 hours of jail calls that Price made or received, and also 5,000 pages of documents, data, and photographs, over 1 year of text messages from Price's cell phone. And finally, also, we are talking about hard drives and flash drives. Now, we got to speak to both lawyers in this case, and we spoke to Brackett, the York County Solicitor. He gave me 20 minutes of his time, and he explained in great detail how this evidence was in a different part of their network. It was simply an administrative error. But when the evidence was discovered on the wrong part of their network, then they immediately turned it over to the defense attorney and, of course, had no problem continuing this case. Now, I want you to listen to a little bit of what Price's defense attorney had to say about it.
It's been on 3 different dockets for trial. Every time it's been continued, the defense has had to file a continuance motion because of a delayed disclosure of evidence. The first time was the DNA report. The second time was a need for me to hire an expert to review that DNA report.
Now, I did, again, speak to Solicitor Brackett. He denies that there's been any kind of discovery problems or trial issues. But the one thing you got from that clip, right? Now we know there is DNA in this case, at least in the first case that's going forward, guys.
Seema, I have to ask you, I mean, I know your resume is very impressive. You were a prosecutor and a defense attorney. But in your professional opinion, did the prosecution do anything wrong here?
Well, Alicia, I was a prosecutor 25 years ago, and things were very different. Basically, the rules across the country were that we had to turn over evidence to the defense prior to trial. Different regions, different counties, everybody has different specific rules. But in 2020, the discovery rules have changed throughout this country, and now prosecutors have very strict timelines on when they have to turn things over. So the prosecution in this case says they were turning over everything in that timely fashion, and it seems like they were, and this was simply a mistake. It was not an egregious error, but it doesn't change the problem that the defense attorney has, that he has a client sitting in jail and he has to get ready for trial. Listen to a little bit more about the struggle that Mr. Hasty went through when he got this evidence.
No, I don't believe there would have been enough hours in a day to even have reviewed it, let alone process it to the point that I would be able to have the recall needed for a trial.
So that's part of the reason this got adjourned, because he just simply didn't have the time. I mean, just think about 5,000 pages alone in 3 days, and we're talking about a mid-sized law firm that he works for, and he's the chief criminal defense attorney there. So maybe he has a paralegal, maybe one other lawyer to help him, guys.
Yeah, all hands on deck situation there, reading through all of those documents. So Seema, Price's lawyer argued that he should be released from jail and the case be dismissed. Was there a legal basis for either of those?
Okay, to be released from jail, there really has to be a significant change in the posture of the case. A victim recants, there's evidence, new evidence comes to light. That didn't happen. And also, to be released from jail or be granted bond, also there wasn't enough evidence. I just want to give everybody an example of a case that you all know about, the Harvey Weinstein case, where an egregious error was allegedly made. The prosecution had the contact information for one of the witnesses, and the defense had been asking for that for years, and that was never turned over to the defense. That's just a better example of what could be argued to warrant either a change in bond conditions or perhaps a dismissal of a charge.